We turn now to the Unified Patent Court, or UPC. We will see how it will work, what its structure and functions will be, how the issues and jurisdictions will be distributed, and the potential advantages and disadvantages of all this. This court constitutes an entirely new system. Basically, it is a court common to all countries participating in the system, not a supranational court. That is, the court would be at the same time a Belgian court, and an Austrian court, and a German court, etc. It is, therefore, a court where litigation related to European patents of the member states will take place through a single legal action that will have effect in all those countries. In other words, this court will resolve cases of infringement and/or revocation of European patents from any of the countries participating in the system, and the judgment will be effective and applicable in all participating member countries at that time. This also implies that the territorial scope of these judgments will change over time as member countries ratify their participation in the system. The UPC will have exclusive jurisdiction in respect of two types of patents, and by patents we mean both these and supplementary protection certificates, SPCs, based on them. It will have exclusive jurisdictions, we said, over two types of patents. On the one hand, over patents with unitary effect, unitary patents, which we have seen in the previous video. And on the other hand, also over classic European patents designating one or more EU member states that have ratified the agreement. However, this jurisdiction in respect of classic European patents that we have mentioned is subject to transitional provisions that we will see in our next video. But first, let's see what the structure of the UPC will be. The UPC shall include a court of first instance and a court of appeal. The court of first instance shall have a decentralized structure, in which there will be a central division in addition to local and/or regional divisions. The difference between a local and a regional division is simply a matter of geographical logistical convenience. There are countries that have decided to have a local division in their territory. In fact, some, such as Germany, will have more than one local division, while others have preferred to group together in a regional division, such as the case of Sweden, Estonia, Latvia, and Lithuania. Each and every division will have multinational panels of judges, which will include judges with legal training as well as judges with technical training. The seat, and thus the administrative headquarters of the Central Division, will be in France, but the work of this division has been divided into three technological branches that geographically have different seats. These are the seat in France, in Paris, which will resolve cases related to telecommunications, transport, textiles, and electricity, among others. The section in Germany, in Munich, where cases related to mechanical engineering, lighting, heating, and armament, among others, will be dealt with. And finally, a section that was planned for the United Kingdom, in London, which would deal with cases related to pharmacy, biotechnology, medical devices, chemistry, or agriculture, among others. With the United Kingdom's departure from the European Union, it remains to be determined what will happen to this branch of the Central Division. For its part, the seat of the second instance, the Court of Appeal of the UPC, will be located in Luxembourg. These two courts, both the First Instance Court and the Appeal Court, will always be subject to the rulings of the Court of Justice of the European Union. In addition, the agreement also provides for the creation of a mediation and arbitration center where patent disputes can be resolved in an alternative way. We have mentioned the existence of several divisions within the Court of First Instance. The question then that can be asked is, why these different divisions? Well, generally speaking, it could be said that the Central Division will be responsible for validity cases as well as non-infringement declarations, while the local and regional divisions will be primarily responsible for infringement cases. The rules, however, can get a little more complicated. Let's look at some examples. Infringement actions must be brought before a local or regional division in a country where either infringement has occurred or there is a threat of occurring, or either the defendant or one of the defendants is a resident or has a place of business. However, if the country in question does not participate in a local or regional division, as may be the case in Luxembourg or Malta, the complaint could then be brought before the central division. Similarly, if the defendant is not based in the European Union, it could also be sued before the central division. Let's look at another example. We mentioned earlier that decisions on revocation must generally be submitted to the central division. However, if it is a counterclaim, the local or regional division, considering the infringement action, may decide at its discretion among one of these three options: continue with the joint infringement and revocation procedure, continue with the infringement procedure but send the revocation counterclaim to the central division, that is, to carry out a process of bifurcation of the two decisions in a similar way to what happens in Germany, for example. And a third option, which would be to stay the infringement procedure pending the resolution of the revocation procedure and send this revocation counterclaim to the central division. There is also a fourth option, which would be to send the matter to the central division as long as all parties agree. If, on the other hand, the revocation action is filed before the corresponding action for infringement, this action for revocation will have to be filed with the central division. The corresponding infringement action then could be brought either before the central division or before a local or regional division. One last example. We mentioned earlier that an action for a declaration of non-infringement must be filed with the central division. But if an action for the corresponding infringement starts, for example, in a local or regional division within 3 months, the central division is obliged to discontinue this action of declaration of non-infringement. We see, therefore, that there can be numerous options, possibilities, and strategies. One of the objectives that have been made public with the establishment of the UPC is the speed of its actions. In principle, cases are intended to be resolved within 12 to 14 months. Once a claim has been filed, the written phase would first take place, lasting between 7 and 10 months. This would be followed by a preliminary hearing with the reporting judge, and then, a few months later, by an oral hearing, which would be held around 1 year after the filing of the claim. The court's decision would be taken within a period not exceeding 2 months from the aforementioned oral hearing. This quick resolution of cases can, of course, be seen as an advantage, especially from the plaintiff's point of view. However, it can be too fast when one is the defendant. Action must be taken quickly and efficiently. Actions before the UPC will be subject to the payment of court fees, of which there will be 2 types. On the one hand, fixed fees for all types of action. And in addition, other fees that will be based on the value of the specific action that is being exercised. These fees will be paid for actions before the Court of First Instance and, again, before the Court of Appeal. In the following slides, we can see the prices of fees according to the current proposal. This would be the fixed fees for the Court of First Instance. As we can see, for infringement actions, the fee would be 11,000 euros. For the revocation actions, the proposed fee is 20,000 euros. Fees based on the value of this specific action will be established by means of a sliding scale, whose current proposal we are seeing in this third slide. These fees will have to be paid again in the event of an appeal to the second instance. Ceilings will also be established for the payment of legal costs in those cases in which the judgment dictates one of the parties to pay them. In this slide, we can see the current proposal for these ceilings. We see, therefore, that submission to the jurisdiction of the UPC entails a series of potential advantages and obviously also possible disadvantages. Among the advantages, we can find the following: a potential reduction in costs when it is intended to enforce compliance with the judgment in multiple countries. Secondly, the possibility of bringing a single infringement action in an appropriate division to obtain a valid resolution in multiple countries. The possibility of obtaining a decision within a shorter period of time than in many of the national proceedings. The possibility that legal actions will be resolved by, at least in theory, a court specialized not only in patents, but also in the technical field. And from the defendant's point of view, and at least on a strictly theoretical level, there is also the possibility of a potential reduction in costs to simultaneously defend against the same alleged infringement or claim for revocation in different countries. On the other hand, there are also a number of potential disadvantages. Among them, we can list the following: the risk of losing the patent in numerous countries, or of there being a ruling or judgment preventing activity in different countries, as the case may be, as a result of a single action. The risk of being subject to proceedings in an unknown EU jurisdiction with little or no case law, whose consequences are effective in a large number of countries. The costs associated with actions before the UPC. As we have seen, court fees will be high, but everything suggests that professional fees will be much higher. And the administrative costs associated with taking decisions on whether to opt out or opt in our patents of the jurisdiction of the UPC. In our next video, we will see when and where we can get our classic European patents, both granted and still in prosecution, out of or into the jurisdiction of the UPC.